A simple noise complaint leads to 4 weapon and drug-related charges in federal court. When the officers arrive to the apartment, the music volume goes down, it becomes quiet, the officers start knocking on the door until they hear somebody come up to it. They then announce themselves as the police and demand the occupant to open the door to have a face-to-face conversation. But can they do that? Or would that knock constitute an illegal warrantless search under the Fourth Amendment? Well, we'll find out today by looking at a case. Welcome back to LAWSTACHE channel. If you're new here, please hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And if you want to support this channel, consider going to LAWSTACHE.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, and some other items. Thanks for watching.
Quick message from LAWSTACHE. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LAWSTACHE YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LAWSTACHE YouTube page. That's LAWSTACHE.
Today we're discussing a Fourth Circuit case, United States versus Mowat. First, let me give you some factual background. Around 9 p.m., officers receive a noise complaint. The security guard for the apartment building says that loud music and a smell of marijuana is coming from one of the apartments on the 10th floor. When the officers arrive, they identify the apartment based on the noise, and they begin pounding on the door. Eventually, the volume goes down, it becomes quiet, and through the door, the officers can hear somebody walking around. They can also hear somebody spraying an aerosol can. The officers continue knocking on the door until they can hear somebody come up. The officers announce themselves as the police and demand the occupant to open the door. But he doesn't. They continue knocking on the door, telling the occupant that they have to get in and have a conversation face to face. Eventually, Mr. Mowat opens the door slightly, about 12 to 13 inches. The officers tell him that they have to go inside the apartment to investigate. Mr. Mowat rightfully asks the officers if they have a warrant, and the officers admit that they did not. At this point, Mr. Mowat refuses the officers to come in, and at this point, one of the officers says that he thought that Mr. Mowat was holding something in one of his hands behind his back. For their safety, the officers grab Mr. Mowat by the shoulder, they force themselves into the apartment, wrestle Mr. Mowat to the ground, and guess what? They don't find anything on Mr. Mowat. But now that they're inside, they conduct a protective sweep to make sure nobody else is inside the apartment. They don't find anyone else, but one of the officers sees a loaded .357 revolver in one of the bedrooms. When the officer comes back to the main room, he sees Mr. Mowat, who's handcuffed, wrestling with one of the officers. The police subdue Mr. Mowat, but in the process, he gets injured. So the police call the medics. When the medics arrive, they take Mr. Mowat to the hospital, but the officers notice that during the altercation, a door to a fridge has been knocked open, and inside they see some pills. Now, based on this information, the fact that they see some pills inside the fridge and the loaded handgun in the bedroom, officers obtain a warrant to search the entire apartment. During the more intrusive search of the apartment, the officers find more assault weapons, cash, and some more drugs. Mr. Mowat is charged in federal court with 4 counts of being felon in possession, as well as narcotics charges. He files a motion to suppress all the evidence found in the apartment because he says that when the officers made the initial entry, they did not have a warrant or a rightful entry into the apartment. He loses the suppression motion, goes to trial, loses at trial, and receives a 197-month sentence. So he appeals and says that the district court incorrectly ruled on the suppression motion. He says that the officers, again, should have never entered the apartment, and that the knock on the door and the initial entry violated his Fourth Amendment rights. Now remember, the Fourth Amendment protects against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct a search. Now here, of course, the officers eventually had a warrant to search the entire apartment, but that warrant was based on the information that they had when they already entered the apartment. Whenever we look at the Fourth Amendment, we have to think about the first interaction between the subject and the police. And here it is when the officers knocked on the door and demanded Mr. Mowat to open it to have a face-to-face conversation. So the question, of course, becomes here, could they do that without a warrant? Because if the court rules that they couldn't, all the evidence that followed, including the eventual warrant and all the evidence that was found after they obtained the warrant, should be suppressed. Here the government relies on one of the exceptions. Of course, if you are new to the channel, you might not know this, but if you've been paying attention, you know that the Supreme Court has enumerated a number of exceptions to the warrant requirement under the Fourth Amendment. One of those exceptions is the exigent circumstances exception. So let's discuss it now. This court has enumerated 5 factors that district courts should consider in determining whether an exigency existed at the time a search commenced. Number 1, the degree of urgency involved and the amount of time necessary to obtain a warrant. Number 2, the officer's reasonable belief that the contraband is about to be removed or destroyed. Number 3, the possibility of danger to the police guarding the site. Number 4, information indicating the possessors of the contraband are aware that police are on their trail. And finally, number 5, the ready districtability of the contraband. The government's first argument that officers requiring Mowat to open the door so they could have a face-to-face conversation with him and see him did not constitute a search under the Fourth Amendment, but that is easily resolved. It is well established that a search occurs for the Fourth Amendment purposes when officers gain visual or physical access to a room after an occupant opens the door not voluntarily, but in response to a demand under color of authority. So of course this is a search under the Fourth Amendment. And the next question becomes whether officers requiring Mr. Mowat to open the door would be justified under the exigent circumstances exception. Now remember the 5 factors I just mentioned to you? Well, think about it. Prior to knocking on Mr. Mowat's door, there was no urgency in the situation. There's nothing to suggest that Mr. Mowat knew that the officers were quote-unquote on his trail. Of course, this is prior to the officers knocking on the door. There was also no evidence that he was purposely destroying the evidence and the contraband. So why did the officers demand that Mr. Mowat open the door without a warrant? The court says that officers here offered no justification for not seeking a warrant prior to knocking on the door, other than the slight delay or inconvenience that obtaining a warrant might have caused. Thus, although the officers had every right to knock on the Mowat's door to try to talk to him about the complaint, without a warrant, they could not require him to open it. Having created the exigency themselves by knocking on Mr. Mowat's door, the officers are precluded from using the exigent circumstances exception. Now the government makes one more attempt in keeping the evidence in. They say that after all, the officers did obtain a warrant to search the entire apartment. But we know better than that. That is not how the exclusionary rule or fruits of the poisonous tree doctrine operates. The exclusionary rule generally renders inadmissible evidence recovered during an unlawful search. It also prohibits the admission of evidence that is acquired as a direct or indirect result of an illegal search, unless the connection between the illegal search and the evidence has become so attenuated as to dissipate the taint. Listen one more time. All the evidence found directly or indirectly from an illegal search must be suppressed. It means that even if the magistrate did not rely on the information that was initially found inside the apartment when he was issuing a warrant, which of course we know he must have relied on that information, there's nothing to suggest that the officers would have even tried to seek a warrant without first illegally obtaining the firearm inside the bedroom and discovering the ecstasy in the fridge. So of course the exclusionary rule applies, and all the evidence inside the apartment should have been suppressed and could not be used against Mr. Mowat at trial. And when I say all the evidence, it includes everything that the officers saw prior to seeking the warrant itself, and everything after. I hope you learned something about the Fourth Amendment today, exigent circumstances, and how a simple knock can lead to illegal searches. I hope you enjoyed this video. Give it a thumbs up. If you're new to the channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, stickers, and some other items. One more time, this is LAWSTACHE.com. Thanks for watching.